Have you graduated high school?
No, sir.
No, you haven't even graduated high school and you're facing a life offense. And then somebody just gives you some simple rules to follow, some simple things not to do. And you can't do that. You can't follow your mother's rules. You can't follow the court's rules. You can't follow any rules.
Judge, we are still waiting on discovery in this matter. It's through U of M and they are notoriously slow. The video, we got discovery from the people, but I believe we're waiting on the video download from U of M.
The current bond in this case, I believe, is a PR bond. I would note that people initially requested $25,000 surety. I would be renewing that request. The counts charged here, as the court can see, are carjacking, assault, intent to rob while unarmed, financial transaction device, as well as receiving and concealing. As far as the people's concern, it's public safety, and that this is a suspect or a defendant who assaulted a completely unknown victim, a stranger, in a parking lot, tried to take her car, took some property from her. She suffered a broken nose, chipped tooth, numerous abrasions. I believe he was then found later with other individuals consuming marijuana despite being under 21. I think that a PR bond is not appropriate given the severity of the charges as well as the facts of this case.
Mr. Margolis.
We'd ask Your Honor to keep the bond in place. This individual was charged originally as a juvenile. He spent 4 days in custody. The case was, he was released, and at the time it was dismissed and then it was recharged. We've been working with the detective in this matter and we turned ourselves in, and then we're able to get the PR bond. Miss Burton Harris was at that hearing, or one of her people were there. I think she was at that one. I can't remember exactly that. Maybe that was Joe. He has no prior criminal history of any sort. He is an A student at Huron High School. He is on a house arrest tether. His mother is in the courtroom or in the Zoom with Mr. Smith today. He is not a threat of committing any crimes. He is not a threat of leaving the jurisdiction. We would ask Your Honor to keep the bond in place. And there's been no bond violations. I don't believe. He said something about marijuana.
Is he testing?
I can't recall, Caleb. Are you testing? I think he did test, but I don't know if he is testing presently.
Testing for what? Sorry.
Alcohol or drugs?
No, they're not testing me.
All right, young man, if I tell you to report to community corrections today to take a drug test, is it going to come back clean?
No.
What's going to show up?
Just it was from school. Just marijuana. That's it.
How old are you?
I just turned 18.
Yeah, that's a problem. Mr. Margolis, how fast can you and your client get down to the court?
Half an hour?
Pardon?
1/2 an hour?
Okay, I'll pass the matter. We'll see you then.
Thank you, Judge.
Thank you.
No.
Not at all, right? In fact, I'm just going to guess. I don't know your mom, but I'm just going to guess she's probably told you not to do it.
Mm-hmm. Yeah.
So you don't listen to her, and you're not listening to me or the court. You just want to play by your own rules, don't you?
No, sir. No, I don't.
Because otherwise you wouldn't have done it last night. Young man, how old are you?
18 now.
When was your birthday?
2006. It's my birthday.
So we turned 18 as I told the court, it was charged originally in a juvenile matter, and then it was dismissed and they recharged as adult.
You understand, young man, that you are facing a life offense.
Yes, sir. Yes, Your Honor.
You understand that?
Yes, Your Honor. And it's taken a lot for me to like to realize what position I am in, and
I don't think you get it. You found yourself in a position where maximum penalty is life or any term of years. Have you graduated high school?
no, sir.
No, you haven't even graduated high school and you're facing a life offense. And then somebody just gives you some simple rules to follow, some simple things not to do. And you can't do that. You can't follow your mother's rules. You can't follow the court's rules. You can't follow any rules. So you tell me why, if you're just going to throw away your life, why I shouldn't just lock you up right now?
No,
You tell me why.
improving, sir, and
Improving how? You're smoking last night. Tell me how that's an improvement.
I do it. I'm gonna tell you why. I usually like need to study or focus study, and it helps me focus while studying. I listen to music, and I honestly like no harm for it, and
You will never do it.
I would never do it again. Like it's I can do it whenever I'm not addicted to it or anything. I just like it because it helped me study.
Great.
I got good. My grades are improved now. Back since I've been out, I've been having
Did
broken.
you tell your mother you needed something to help you study?
I said I prefer. I actually
Did you tell your mother that?
no, no, sir.
Because you're just so grown, you took it on your own.
Sorry. I was trying to do things on my own, and clearly I messed up. And this just shows that I need my mother to supervise me and to.
You're not listening to her. I don't, and I'll be honest with you, I went through the bond form, Mr. McGoes. I don't understand how he has a PR bond. I don't.
So the family would not be able to make a high cash bond or a significant money bond. He came to the court with no prior history of any misconduct. He is high school senior on track to graduate. I explained to the magistrate how the family has all come together to take care of this, help assist this young man through this time. He's on a tether on house arrest. All he is able to do is go to school and church. And I believe those are the two places that he's gone to.
Yeah, those are two places that I've only been.
He is not a risk of committing any offenses, not a risk
Yes,
of
he is.
any.
Because he did it already.
It's possible, and not to excuse anything here, Judge, but it's possible that I didn't explain the conditions sufficiently to this young man.
How's that feel with your sword in your chest?
I don't think I understand the court.
I don't mind attorneys falling on the sword for their client,
Thank
but
you.
this young man is not listening. He is not. He is just going to decide to do things his way. And I think his problem is he's running to the wrong judge to try to do stuff his own way.
Understood, Judge. I would suggest that perhaps if he were to test regularly and prove to Your Honor that he does respect the court, does understand what he needs to do.
You know, Mr. Margolis, I don't mean to interrupt you.
No worries.
It's almost not so much about respecting the court, although I do require that. But you know, I'm sitting up there watching on the Zoom screen, and I see his mom just standing beside her child. And it's the fact that you don't respect her that is really irritating me. And because of that, you're not even doing the things to respect yourself. You're an 18-year-old kid up here facing life for what? And again, I don't know your mom, but you got these charges come up. You got your mom scared to death.
If Your Honor would like to speak with her, she'd be more than happy to talk to the court. Right?
I'll tell you what, I'll hear from mom on my
Your Honor, and I probably mentioned this already, but he's in his last semester. My concern is that if he's detained for long.
Oh, I know.
Yeah, I know Your Honor knows.
I know.
I just wanted to put that out there. And
You know what? If I don't care about his education, about his life, what if he doesn't care? Why should I?
I think he does care. I think he's just made some mistakes. And
He's not listening.
He's never talked to you before.
Oh, I can tell.
Meaning he's listening to you, Judge.
Mom, is there anything you want to say? I know this is not. Excuse me one moment.
Please.
Let me see where he wants her to speak. Step back there, of course.
Put him over there with you, Alan, and then mom can come up so I can hear her.
Right here, man.
Mom, you can come on out. State your name.
Nicole Barrow.
All right. What do you
Thank
want?
you.
What do you want to tell me?
I know most moms will say that they have like a good kid and they give you this long spiel and then they do something bad and they're like, oh no, you should believe it. But when I tell you, like, I'm in shock, utter shock. He was really a good kid and still is. I did not know. I knew he had a vape, but it wasn't marijuana. And I did tell him it was bad for his lungs. Prior to that, he was my only child that I knew for sure was going somewhere. He's never smoked, never been in any trouble. Him and his brother had started a business where they were selling hoodies in school. He would even be the one, helping me around the house. He's got a brother 16 months apart from him. I moved up to Ann Arbor 8 years ago so that he could go to a baccalaureate school because my two oldest children went to Cass Tech. His older brother went to Eastern and somebody laced his weed and sent him on a trip. By the grace of God, he came back. He's got a degree now. He's going to U of M this fall for software engineering. He even got a STEM scholarship. So that was the example that I was showing my younger children. Don't smoke weed. Don't hang out with these kids. Started hanging with some new kids that were older than him in college. And then I think turning 18, he thought he could,
Just
be
thought he was grown.
rebellious and grown.
Yeah.
Yeah, and not knowing. I just ask that the court show mercy, and I know this isn't something light or to be taken lightly, the charges that he's facing. We don't consider it lightly. We come from a good background. Our family, civil rights activists. I don't know if you ever heard of Willie Barrow, my aunt.
Yes.
Joe Lewis, my great uncle. I'm doing well at Blue Cross. I'm making a name for myself with the CEO. I'm back in school.
Ma'am,
So he comes from a good
stop
family.
you.
I'm sorry.
I do not doubt that at all.
Yeah. So this is hard.
I do not doubt that you as a mom have tried to do everything within your power to give him the tools and everything else so he could succeed. That is not a doubt. Like I said, I don't know you, but when I saw you on the screen, it wouldn't be easy for you, but if you just walked away from your kid that might have done wrong, I don't know that anybody would blame you necessarily. You didn't do that. You were standing cheek to cheek with him.
Yeah.
So understand any decision that I make, it's no reflection on you.
Sure. I understand.
But what I also understand is I've been doing this long enough to realize If he keeps getting away with this stuff, he's either going to end up in prison or in a casket. Don't shake your head because you have no idea. You think you know too much, but I'm going to show you about what you do know. Mom, is there anything else you want to tell me?
He thought marijuana was legal and he could do that. And then they didn't tell us the probation. I know it's wrong, but they didn't give us restrictions or say anything to him. And I think he didn't know it because that's what he said coming in. If that, I know it's not helpful.
I got you.
I thank you
His
for
bond,
allowing
his
me.
bond conditions are what his bond conditions are. I understand they may not have told him, but you told him.
Yeah,
He knew.
I did tell him. And I just asked if you do make a bond, can you make it affordable for me? It's just me. And then I've been missing work already. I've missed almost a month. They're on me. I got to go meet with my HR on Monday about my job. This is so hard. And I told him I was only messing up at work because of this. I thought I could handle it.
Okay.
I'm sorry.
No,
I'm
do
so
not
sorry.
apologize.
I'm so sorry.
What time's your appointment on Monday?
In the morning when I go to work at 8 a.m. I work in Medicare Advantage out of the Blue Cross. It'll be 2 years in May.
What time do you get out of work?
4:30. You're right.
All right. Okay. You work, how far is it from your work to here?
It takes me about 45 minutes.
To get here?
Yeah.
All right. Okay. Thank you.
Thank you.
Anything else from either side before I do what I'm going to do?
Your Honor, the people's original request was for $25,000. That was before the people were aware of the new violation with the marijuana. This time, people will be requesting remanded for the violation. I know the court indicated I've gone through the bond request form. I know my colleague did a fantastic job outlining all the facts. I did just want to again emphasize the severe injuries and assault that occurred on one of the victims here with the broken nose, chipped tooth. She was bitten her hand as she was trying to fight the defendant for control of the car keys. I think remand is appropriate at this time.
Margolis.
I have nothing additional to add, Judge. This isn't the time to talk about the facts. We do have compelling defense to this case, but I'm not going to get into them now. This is a first offense, first charge of the lifetime for this young man. The family does not have money to pay a high bond. I would, if Your Honor was going to change the bond, I would suggest something in the range of 10 to 25,000, 10% if possible.
But if I make it higher than that, then family doesn't have it, and then he doesn't graduate.
Correct.
And everything's a mess.
Correct.
Man, anything you want to say?
Hold on. I just want to say that I do learn from my mistakes. I'm getting closer to God. I know I do look at my mistakes and I know it impacts my family and I know it impacts my mother and it really breaks my heart. I've been improving. I've been improving in school, my business. I'm helping opening up a business today actually for pregnant women for a pregnancy pillow. Like I'm trying to like do the right thing and I won't smoke again. That's no problem for me to not smoke again. I won't like. Other than that, like I've been following my probation rules. I've been texting my probation officer. I have not committed any other violations. I've been going to school on time, and I really apologize to the court. I'm sorry. I apologize to you. And that's it.
You know something? I'm sitting there listening to your mother, and then understand something. You will never, ever possess the right to break her heart. You just don't have that right. Normally, an easy thing for me to do is to accede to the people's request. If I accede to the people's request, you're not out. You don't graduate. Everything becomes a whole mess. But it also seems that if I let you out, you can't seem to follow the rules or do anything. So what I'm going to do is I'm going to think about it. And I'm going to decide what I want to do. But you're not leaving here today, Mr. Allen. What I'm going to do is I'm going to revoke your bond. You sit there and you think about it. I'm going to set a bond hearing 4 o'clock on Monday, 4 p.m. I'm setting 4 p.m. so you can get into the building. Ma'am, get to work. You get here. We'll be here. We'll wait for you. Okay? We'll finally have somebody that's waiting on you as opposed to you waiting on everybody else and everything falling through. But what you're going to do, young man, since you can't seem to understand what kind of life you're kind of headed to, you ever been in jail?
Yeah.
For how long?
They put me in here for 4 days.
On this
Okay.
case, Judge.
Well, you're going to be back in. And then when come Monday, you might just stay in. You have nobody to blame for this but you. So at this time, defendant is remanded. We'll see you on Monday. Calls case People versus Real Page Power.
Joseph and Gulliver people. And greetings, Your Honor. Emmett Greenwood on behalf of the defendant, P56556.
Real Page Polly, Your Honor.
All right, what are we doing on this case?
Your Honor, after discussing this matter, both matters with my client, we elected to waive both matters.
All right. So we have one other matter, and I am not even clear what to do about it.
Yeah, would you like to be the approach counsel?
No, because I'm just going to do it on the record, and I'm just going to say this. I don't know why you were show cause. There's a show cause here.
We respectfully ask that the show cause be set aside.
Oh, it's going to be dismissed because I can't do. He said it. I don't know why Judge Barr even sent it to me. Judges need to understand if you're going to show cause an attorney, then you handle the darn thing yourself. Well, almost messed that word up. I'm not doing it. So I'm dismissing the show cause.
Thank you so much.
Because as far as I'm concerned, you could have been in that building walking around anywhere. I don't know. So I'm done with that. Show cause is dismissed. You don't even have to worry about it from here. And then you can go up before Judge Conkey.
Okay. Thank you again, Your Honor.
Defendant's bond will continue. Thank you.
Good meeting you.
I appreciate it.
He'll be back in a week. What? We're rooting? Oh, okay, we're rooting.
Good morning, Your Honor. James Feifelsky appearing on behalf of Mr. Burmeister, who is approaching. Good morning, sir. Please state your name for the judge. Kyle Burmeister. Your Honor, this is our first PCC. I am asking for a 30-day adjournment. One of the things I need to gather are medical records that I think will be relevant to our defense or potential resolution. And those often take more than a couple of weeks.
Who's medical?
My clients. Got signed releases that are going out today.
Unlawful driving away, and I don't,
Well,
not understanding it.
I think they'll be very relevant to the RO charge and medical history that I think will be important to review with the prosecuting attorney.
Any response from the people?
Your Honor, we have one moment.
Sure. Got all the time in the world.
Your Honor, may we briefly approach?
Didn't have that much time, but yeah, come on.
No, all I saw the paper was this. Right, okay. There was only one. It was today. Your Honor, just to advise the court, when I told him that apparently he missed a court day yesterday, it's not a case I represent him on, but he tells me he has never received a notice. He had a notice for today, and that's why he's here. We've communicated about this case, but he was not aware that there was a hearing. So if the court
Well,
can
that's a bit
rein
odd.
him on
That's
that.
a bit odd
Sorry,
because he didn't appear, did a warrant recall, and then didn't appear again.
nobody, anything about, you know about another case? Is that a misdemeanor case in this court?
It is.
A misdemeanor case?
Nobody told me when I left on Thursday from the jail that this was the only court date that I've had at all.
He was arraigned, I believe, last Thursday on this case. Is that what you're saying?
Yeah.
You're in the jail. They released him with
And they-
paperwork for this case.
Yes.
So I sounds like it's an innocent mistake. He had no notice of the hearing, but certainly he's here to handle whatever legal matters are in front of this court.
Probable cause conference in the matter that were called upon today will be adjourned to March 13th,
I apologize.
2025, 9 a.m. On this other matter, he got a warrant. He recalled the warrant. The date was set. He didn't appear the first time. Now, granted, there was a snow day, but then he did not appear the second day, and notice was sent out. I recall the case from yesterday because he had the previous warrant, and when I issued this warrant, and he just wasn't here.
To the court's knowledge, was he appeared somehow to recall the warrant, or he communicated with the court?
He communicated with the court to recall the warrant, the first warrant.
Okay.
There was, got dismissed, and that was one other case that I knew about, and I pled guilty to it.
Tell you what, he's going today. He'll get a date, and then he'll appear, and I'll let the magistrate set the bond on it.
Okay, we
At this point,
appreciate
defendants remanded on the
the
warrant.
soonest available hearing that the court can offer. Thank you, Judge.
Name for the record.
Rashard Young?
Your Honor, at this time, we would like to set this matter for a PE.
Your Honor, two things. One will be addressing bond when time's appropriate, and then also recently I was reviewing this case, saw on the body cam, we didn't have a different body cam. I requested that today, so we don't have all the discovery. I'm awaiting one more body cam video from a different date that is related to this incident.
If I may, Your Honor, Lauren Brown, Deputy Chief Public Defender. We did speak about that. She expects to have that today, and we think that that'll give plenty of time for us to be prepared for a clinic session. The one works for us. We'll be ready.
It's one body cam.
I believe so, Your Honor.
Okay. There won't be an adjournment of this proceeding if that's not available, but I'll set it. Will people have their witnesses available the 4th?
We'll do our best, Your Honor.
Preliminary examination in person, March 4th, 2025, 9 a.m. before Judge Perry. Continue.
May I?
Oh, maybe not. Go ahead. I'm sorry.
Your Honor, as you probably recall, last week we addressed this defendant's phone privileges. After those were revoked, he then continued to call the victim at a different number that we have under her name as well. He called her, I believe, 23 times. There were some under his own PIN, and then after the first day he was in custody, he started using other inmates' PINs to continue to contact the victim in this case. So we have great concerns still that he is still continuing to contact her against court orders.
Your Honor, may we approach?
Yes.
Recording still.
All right. Record should reflect we had a bench conference in this case. Go ahead. Anything?
Yeah, may I also address, our client has a job interview on the 24th of February and at 11 a.m. And we were wondering if you would able to either give a PR bond or a tether to allow him to go to the job interview.
Well, here's part of the problem with this case, and I'll certainly let the people respond. This case came to my attention for various reasons. There was a hearing, really a hearing, but I heard from the alleged victim in the case. And then upon getting more information, it seems that the parties did not stop contact upon this case and may have even appeared at court together on the date that they were here. Further, the defendant got remanded in part because of phone conversations, then gets remanded this time and still can't follow the court's order. So I'm not going to change his bond. You can certainly, after prelim, make the argument before Judge Perry, but I'm not changing anything regarding his bond. He'll just remain there, and you know, his phone privileges are revoked, but he's still trying to have contact. So, motion for bond reduction denied. Got to follow the court's orders. Court calls the case of the people versus Barrage. Ante Scott. 2 cases.
Morning, Your Honor. Green Cook for the people.
Chair for Barrage Scott, Barrage Ante Scott.
Barrage Ante Scott, sorry. Thank you. All right, what are we doing?
Your Honor, Mr. Scott would like to, we're here on 2 cases today, and Mr. Scott would like to waive his preliminary exam in both cases and address bond.
Okay. All right. Is that correct, Mr. Scott? You want to waive your right to a preliminary examination in these cases?
Yes, sir.
And as far as bond, if I may address that.
Why don't we do the waiver? Why don't we?
Oh, yeah.
Arraignment, and then we'll address bond.
Okay, thank you. Sorry, Your Honor.
You waive formal reading of the complaint,
Yes, I waive formal reading of the complaint.
and your client standing mute to the charges.
Yes.
And we waive formal reading, standing mute. Both counts, court will enter a not guilty plea. Pre-trial in this matter will be set for March 6, 2025, 1:30 before Judge Slay. As to bond.
As to bond, I believe Mr. Ante Scott is being held right now on case 25FB1013. There is a 5,010% bond on that case. My understanding is that this court gave Mr. Ante Scott a personal recognizance bond, a $5,000 personal recognizance bond yesterday in case 2411706. I do believe that the reasons why a personal recognizance bond would have been justified then count for this case as well. Mr. Scott is not a flight risk. He lives in the community. He is willing to follow any kind of conditions the court sees appropriate in order to be released. He would just like to.
No, he's not.
He would just like to return.
He's going to give, I will say this. Don't look at me like that, Mr. Scott. We've been through this before. He's going to give his best effort. He really is. He's going to try his hardest. And then it just happens. Go ahead, counsel. I didn't mean to interrupt you, but I just had to, because I know Mr. Scott told you that.
Well, on Mr. Scott's behalf, it is just this one case that is holding him, and it does appear he has personal recognizance bonds in all other matters that he has. So I would ask, just because Mr. Scott would like to be able to kind of, family, attend to his health matters, and work out in the community while he is handling these cases. He would request, and I would request.
He got to go see now. Which family member?
My grandma, my granddad.
Okay,
and just my sister and stuff, the people that was helping me out in the past years, that my auntie. And I won't, I'm just gonna do the right thing. Just bear with me one time.
One time?
I mean.
How many times have you been here? Can't even count that high, can we?
No, sir.
No, we can't.
But I will do what you tell me to do. Just please.
Anything else, counsel?
I would just like to, reiterate that I understand that a matter was before this court yesterday, and it seems like a personal recognizance bond was appropriate at that time.
Only because I knew it was going to be held on this one. But go ahead.
Well, I'd ask the court to consider this bond motion in light of the argument presented.
Response from the people.
Your Honor, I leave it to the court's discretion.
Just tossed it right in my lap. Okay. What is my case that I have on? What was your charge on the case you had before me yesterday?
Just a paraphernalia gave me personal personal bond, and you told me conditional yesterday, and I thought I was leaving yesterday, but that's
I know.
And Your Honor, I would add that Mr. Ante Scott is willing to go on tether in this court if that is.
We tried that too.
If
the only thing the tether did for us is we saw where you got in trouble.
I won't get in no more trouble. I won't.
Sometimes I have no idea what I'm doing. I'm going to grant your motion for a bond reduction. I'm going to give you a PR. Barrage?
Yes, sir.
Understand something.
Yes, sir.
You still have the case before me. Okay?
Yes, sir.
So if you mess up, you know what I'm going to do.
Yes, sir.
And then I don't want to hear any whining and pleading.
Yes, sir.
Here's the other thing I'm going to do. I'm going to call Judge Slay.
Okay.
And I'm going to let her know what I did.
Okay.
And if you mess up, you're going to have both of us to deal with.
Yes, sir.
And I don't think anybody wants to deal with that.
No, sir.
All right.
So can I ask one question?
Oh, boy.
Mr. Scott, I would advise you.
No, you can go ahead and ask a question.
No,
I may change my mind. Go ahead. What's your question?
No, I was just going to ask you, I can't remember. It's okay.
You couldn't remember?
I can't remember.
It left you, didn't it?
Yeah.
Yeah, that's probably a good thing.
Okay. That's all I want to say.
That barrage, that's angels just stepping in and stopping you from doing something stupid. All right. Thank you.
Thank you, Your Honor.
He'll be back in a week. What? We're rooting? Oh, okay, we're rooting.
Notice the radio silence.
Yeah, no, everybody over there is not. Everybody from the prosecutor's office. We have faith. Yeah. All right. Nothing from the defense side. All right.